Welcome to Introduction to Criminal Liability, Legal Research, Understanding Precedent. Now, as we discussed last time, there is a danger in using the Google site search because Lexis and Westlaw do what's called shepherdizing cases, which means that they'll let you know if a case has been overturned, if a court has changed its mind, something like that, or if a statute has changed, anything like that. So if you're just using Google, if you're using the site search, you will not have that information. So once you find a case, you need to make sure that case is still good law. Well, how do you know if something is good law or not? Well, the first thing you need to understand is precedent. Precedent is sort of a judicial chain of command. We have binding precedent. Basically, if there is binding precedent, a court doesn't have a decision. If there's binding precedent, and it applies, then the court must follow that binding precedent. So the decisions of other courts, though, can be persuasive authority. Basically, if you have a case in front of the Fourth Circuit, and you say, hey, Fourth Circuit, this is what the Sixth Circuit did. You should do this. The Fourth Circuit will listen because it's a sister circuit. They will consider it, but they do not have to go that way. That is regarded as persuasive authority. Now, what if you go to the Fourth Circuit and you say, hey, Fourth Circuit, this is what you said last time? Well, a court doesn't have to do what it did last time. It should. We call this stare decisis, basically letting the decision stand. Once a court decides something, they shouldn't change their mind. However, they do it a lot. So just because a court has held something one time does not mean it's not going to change. Usually they're supposed to only do it if there's a good reason, but again, that is not how it always goes. So let's find out a little bit more about this binding precedent. Each court system is broken into three categories. You have your trial court, you have your intermediate appellate court, and you have your court of last resort. Usually the way it happens is the trial courts are the fact finders. They listen to evidence, they decide who to believe, who not to believe. The intermediate appellate courts, if you lose in trial, you usually get to appeal to the intermediate appellate court automatically. They have to listen, they don't have to agree with you, but they have to consider your appeal. After the intermediate appellate court, if you lose there, you can request that the court of last resort review your appeal, but they do not have to. They have a choice. So the intermediate appellate court has to listen to your appeal, and they decide whether you are right or wrong. The court of last resort is another appellate court, but they do not have to take your appeal. They have discretion in deciding whether or not to. And the way that it works is the court of last resort binds the intermediate court binds the trial court, and the trial court stands alone, much like the cheese. Now, the intermediate courts usually sit in panels of three. The Maryland Court of Special Appeals is the Maryland Intermediate Court. The United States Fourth Circuit sits in panels. They are the intermediate federal court, and they decide cases that way. But because the panels are different, one panel might think one thing, a different panel might think something else. So what happens sometimes is the intermediate appellate courts get together and sit en banc, meaning that all of the judges in that intermediate court sit together and consider a case. This forms sort of a super panel that's going to bind any later panels to consider a case. So you have your trial court, you have your intermediate appellate court, you have the super panel, the en banc intermediate appellate court, and then you have the court of last resort. And that's sort of the hierarchy in the judicial system. So as I was mentioning before, you have your federal system, and the top of the federal system is the Supreme Court of the United States. What the Supreme Court of the United States says about federal law is binding on everyone below them. The next step down is going to be the United States Court of Appeals for whichever jurisdiction sitting en banc. So if we are in Maryland, Maryland has the United States Court of Appeals for the Fourth Circuit. If they sit en banc, then the only one that can overrule them is the Supreme Court, or if the Fourth Circuit gets together en banc again later and changes their mind. Below that, you have the United States Court of Appeals for whichever circuit. Again, in Maryland, it's going to be the Fourth Circuit, and that's a three-judge panel. And they can listen to what they've said before. They're not supposed to change it, but they can. But their decisions are binding in the District Court of the United States, as well as the magistrate courts. So any federal trial courts below them are going to be bound by the United States Court of Appeals for the whichever circuit. And then you have your trial courts below that, the District Court of the United States for whichever jurisdiction, and your magistrate courts. In Maryland, at the top of the food chain, you have the Maryland Court of Appeals. The Maryland Court of Appeals is the last word about Maryland law and the Maryland Constitution. Even the Supreme Court of the United States has to listen to the Maryland Court of Appeals with regard to what they think about Maryland law and the Maryland Constitution. Below them, you have the Intermediate Appellate Court. You have the Maryland Court of Special Appeals. So the Maryland Court of Appeals is the last word. They can change their mind, but other than that, that's it. There's no binding precedent with regard to Maryland law and Maryland Constitution. Below them is going to be the Maryland Court of Special Appeals sitting en banc. So if the entire Maryland Court of Special Appeals gets together and decides something, the only one that can overrule that is the Maryland Court of Appeals, or if the Court of Special Appeals sitting en banc changes their mind. Below that is the Maryland Court of Special Appeals as they usually sit, which is in a 3-judge panel. Below that you have the Circuit Court, and below that you have the District Court. And the District and Circuit Courts are trial courts. Now, in a normal situation, you have your federal system and your state system. The United States Constitution is sort of a special exception. The United States Constitution trumps everything. And the interpreter of the United States Constitution is the Supreme Court of the United States. So what the Supreme Court of the United States says about the United States Constitution is going to be binding on both systems. So if the United States Constitution says something, the Maryland Constitution, Maryland law has to bend to that. So the Supreme Court of the United States is sort of the last word when it comes to United States constitutional issues. Thank you very much for listening. Bye-bye now.